Welcome, fellow officials, to the Michigan High School Athletic Association, another edition of Officiate Michigan Day. Gathered here today are a panel of fellow officials from across the state in a variety of sports, but also, and perhaps more importantly for this session, we're all lawyers. We're all members of the bar of the state of Michigan, and we all have specialties that may help you navigate the legal waters that surrounds sports officiating in our great state. So that's what we're going to be talking about for the next hour. The name of the episode is Legally Speaking, a Conversation with Attorney Officials. I'm going to moderate this. I'm David Layton. During the day, I'm the Genesee County Prosecuting Attorney. That's Flint and its surrounding communities. And on Friday nights in the fall, I put on the stripes, and I'm a football official for upwards of 20-some years. And I already have my schedule, so I'm ready to go this fall as well. So welcome. I hope that you find some good things coming up here in the next hour. What we're going to do first is we're going to go down the panel so everybody can introduce themselves to you, and you'll know what sport they officiate and what kind of lawyer they are within our state. They're all fine lawyers, but they're going to tell you what their specialty is. So let's start on my right with Mr. Paul Spagnola.
I'm Paul Spagnola. I retired in December of last year as the Mason County Prosecuting Attorney. That's in Ludington. After being in the prosecutor's office for 20 years. Prior to that, I had a civil practice and private practice in Ludington. But my sport is soccer, and I've been an MHSAA soccer official since 1997.
Hi, I'm Dana Graham. I am a competitive cheer official and coach. I've been officiating for probably 6 or 7 years now, coaching for about the same time, some of it overlapping, some of it not. My prior experience, I've been a licensed attorney for 10 years, prior experience in the court administration world, and now more recently I work in-house at a software company focusing mostly on service delivery and contract administration.
I am Bruce Moss. I'm a private practice attorney in Gratiot County, which is Alma, Ithaca, and other communities. I officiate football, basketball, baseball, and softball now for over 40 years. My practice is almost all now criminal law and juvenile cases.
Hi, I'm Fred Butters. My practice is located in Oakland County. I officiate football, basketball, and softball. I'm closing in on 20 years with that. I've been in private practice. This is my 30th year, and I specialize in professional liability and personal injury defense.
My name is Sheldon Larki. I'm a magistrate in the 52-4 District Court serving the cities of Clawson and Troy. I've been an attorney for 51 years. I also mediate and arbitrate and facilitate civil cases of all types. I've been a soccer official with the High School Athletic Association for 31 years.
Thank you all panelists for being here. And so we have a wide variety of specialty on this group. We have a magistrate judge, we have civil practitioners who defend people when they get sued, we have prosecutors who bring cases against those accused, and we have a criminal defense lawyer who represents those who are accused. So we are able to bring a wide perspective tonight. But one caution, none of what we're saying tonight is absolute legal advice to you personally with respect to a matter you have. All of what we're going to talk about tonight are hypothetical matters that might come up, and you can take some of what we say and apply it. But obviously, if you get into a pickle, if you're ever sued, if you have a potential legal issue, you really do need to seek out a competent lawyer in the field in which you are perhaps getting involved in litigation. So I want to give you that caution before we go on. So what happened is, prior to us coming here for this session, the assistant director of the MHSAA Brent Rice, who was all of our bosses basically for officiating, sent out a request across the state for some questions and developed some questions on his own with the help of his staff. And we are going to cover some of those questions tonight and engage in a discussion about the law and sports officiating. So let's get right away to it. The first question we have is, what protections does the MHSAA provide registered officials if they are sued for incidents that occur during a game that they officiate? So I thought maybe, Fred, we could start with you, since you do a lot of civil defense work and might be in a position to represent somebody who gets sued.
Thank you. That benefit is significant. Having the insurance backing is great. The insurance carrier steps in, picks up the defense, and you really at that point have to cooperate. That's about the extent of your obligation. Most, in fact, all carriers I've ever worked with are incredibly responsible and responsive in that regard. One caution, however, we have to bear in mind that insurance covers us for accidents. It's an accidental failure to comply with a requirement or an accidental failure to accomplish something that we seek to accomplish. We're not covered for things that we do intentionally. Now, in my experience, very few insurance carriers raise that as a defense. But if we apply that to officiating, if we do something intentionally, for example, we see lightning and we don't comply with the lightning protocol, we're getting on thin ice in terms of that insurance coverage. So it is very important, first, that coverage is in place, which it is. And it's also very important as an official to comply with the protocols and the requirements to the best of your ability. We look at things like, well, that's lightning and it's way over there. Well, yes, but I don't want to be the official that thought the lightning was way over there and now it's here. And it's relevant to this question because it can, in some circumstances, compromise the carrier's obligation to provide the coverage.
I think it's important to note that if you are a registered MHSAA official, the MHSAA provides you with up to $1 million of liability coverage should a registered official be sued. And that starts right with the first dollar. And what that money will do is it will hire you a lawyer. I mean, you've got to have a lawyer when you get sued. You don't want to go to court by yourself. That policy will enable you to find a lawyer, hire that lawyer, and that lawyer will be paid from that insurance policy. Anybody else want to weigh in on this question?
I think it's important that we've mentioned registered. We've used that word a few times. So if you are thinking, oh, I was a little late signing up this year, I don't have my accurate, up-to-date registration, but it's no big deal, I can go. That's not the game that you want something bad to happen. So make sure that you are a registered MHSAA official to be able to take advantage of that protection.
And the other thing that I would say is make sure that at least one of the schools is an MHSAA school. If both schools are not, there is no coverage.
And we are going to talk further about the various responsibilities that you have so that you don't get sued, so that you don't need the coverage, so that you don't need to hire the lawyer as we get into some of the other questions. So our second question tonight is, what does the law consider to be good faith when determining liability, protecting players, and mechanic or rules enforcement mistakes in officiating? I will say this before I open it up to some of the panel members, that, you know, in every contract, there is an implied covenant that neither party shall do anything which will have the effect of destroying or injuring the right of the other party to receive the fruits of the contract. When you're an official, you're entering into a contract that you're going to officiate a game or a contest, and you're going to do it to the best of your ability, and you're going to come to that contest having been prepared to do it to the best of your ability. And you're going to hear this over and over tonight. You got to know the rules of the particular sport that you're officiating. You have to know the mechanics of the particular sport, because if you don't know the rules and you don't know the mechanics, you haven't prepared yourself properly to perform in good faith. And then you're opening up Pandora's box to a whole host of other issues. Bruce, you want to take a shot at this one?
Well, good faith. I made the notation, the path to perdition is paved with good intentions. So you have to have more than good intentions, and I think that's what you're talking about making sure that you follow rules. That's evidence of good faith.
Anyone else on this one? I would add a couple more things. I made some notes here about this particular question, that you have to show professionalism. And what does that mean? That means you present yourself as a professional when you show up for the game. Your physical appearance is important. Your knowledge of the game is important. You arrive at the event in a clean, crisp uniform. You make a good impression, and you begin to gain respect from those that you are serving. You got to know the rules. We mentioned that. You're not going to be excused if you miss a call or you misstate the rule or misinterpret the rule, but you're not likely to be successfully sued either if you mess up there. I was looking at some case law going back 30, 40 odd years where there have been instances where sports officials have been sued for making the wrong call. The most recent one was in the state of Illinois in a football playoff game. That case went to court, and the judge said, you know what, the courts don't have jurisdiction to overturn the calls of officials who may have made an error in judgment, who may have misinterpreted the rules. The courts aren't going to get involved in that, so that's not something that you really need to worry about. Further with good faith is approachability. You need to be approachable when you're out there. There shouldn't be a discussion over every call, but valid questions should be allowed to be voiced respectfully, and that will almost every time diffuse tensions. Coaches who typically dispute a call just want to be heard, and they really don't expect a reversal because reversals are extraordinarily rare. And I think too that when you are approachable and you can have a meaningful discussion, you're going to reduce tensions. And if you reduce tensions, you're likely to not end up with a situation that could turn into something for which you have to worry about your own personal liability. So those are some things that I think have to do with good faith. Anyone else on the panel on this question? Okay, moving right along. What are some of the lesser known sources of liability that officials may not consider but need to? Who do we have on that one?
Well, I have one.
Shel?
This is, you have to understand my history. I was an old claims adjuster many years ago. And one of the things that we did with automobile insurance claims is we always asked people, where were you coming from and where you were going to? And one of the things that people fail to remember is, if you're traveling from work, from your regular job to employment as an official, you are going from work to work. You are not going from home to work. And as such, there's different insurance coverages, vehicle insurance coverages. And what I mean by that is you have no coverage if in fact your vehicle is only used going to and from home or for pleasure purposes. But if it's going from work to work, you have potential liability coverage. So the first thing I would do is, if I'm working at a job and I'm going to officiate later in the day or earlier in the day and then going to work, I would want my insurance agent to know in writing that I am traveling. That it becomes a possibility to pay a little bit extra for premium, but that premium will pay you and protect you. An additional thing that I would consider for lesser potential liability is maybe $1 million is not enough coverage. Maybe you're sued for a greater amount of money I would also consider the possibility of buying what is called an umbrella insurance policy. And typically speaking, an umbrella insurance company costs less than $200 a year. I would always consider that as a potential.
Yeah, I think that's excellent advice. Umbrella policies, for those of you out there, kick in when the initial policy, the underlying policy, pays out all the money. So you've previously heard that the MHSAA provides a $1 million policy. Let's hope it never happens, but if it were to happen and that $1 million was used up, then that umbrella policy that you purchased would kick in and would allow you to have further coverage. Anybody else on this issue of other liability? Paul?
I think Sheldon makes an excellent point on an umbrella policy, that it would be very beneficial to you to have one. Liability that an official can have can be substantial, particularly if there's an injury, a catastrophic injury that occurs to a player during a game. For instance, if those equipment was not properly installed at the facility, for instance, as a soccer official, we have to inspect the portable goals on every game, and if we don't inspect those goals on every game to make sure that they're anchored or counterweighted, then we're going to have liability. And if a goal blows over and strikes a player, the injury can be catastrophic, and $1 million may very well not be adequate to compensate the injured player. So it's extremely important, number one, that you have adequate coverage for such a situation. And second of all, it's critical that you do the requisite safety inspections for your sport. I can't say that enough. Don't rely on the official that was on the prior game on that field or at that facility to have done that. Do it yourself, so that if there is a situation that's presented, then you can say, when your deposition is being taken, yes, I took care of my responsibilities, I followed the policy, I followed the protocol as I do on every game, and if the game starts a few minutes late because you were delayed for some unintentional reason, make sure that your safety inspections are done, and every sport has those safety inspections. Know what those safety inspections are for your sport, and don't delegate it to somebody else.
And if I could follow up on that, safety rules, a violation of a safety rule by an official, in my professional opinion, is intentional. That's intentional acts on the part of that. That's not negligence. That's reckless disregard of a rule. And there is no coverage for ordinary negligence, none whatsoever, for violation of an absolute safety rule. So if there is a safety rule in your sport, you have to obey it. There's no ands, ifs, or buts. It is complete liability on your part by ignoring it.
And I think it's important to think about, and we talked about this a little bit, is that specifically to say what are some areas of liability that we as officials haven't thought about. There could be 1,000. I think the point is, and where insurance could help or provide some protection, is if something bad happens, everybody's getting sued. The school's getting sued, the coaches are getting sued, the officials are getting sued. And officials, other than the insurance, have a little bit less protection in terms of governmental immunity or those sorts of arguments that can be made to kind of reduce some of that liability. So I think that that's probably why you're hearing us say over and over and over, be aware of the insurance, be aware of your intentional acts, and make sure that you are doing all of the things that you're supposed to do so that hopefully the lawyers are never involved.
There's one other thing. Michigan recently enacted a athlete concussion rule. That rule puts liability on the part of officials that if they suspect that there is a player, a student athlete, who has a concussion, they must remove them from the game. There is a current case before the Michigan Court, just 2 months ago, the Michigan Supreme Court sent back to a circuit court a case called Randall versus Michigan High School Athletic Association. And in that case, the case from the Court of Appeals clearly indicated that there is a duty on the part of officials when it comes down to concussion. So there's another specific statute regarding concussions. We have to be trained in it, we have to know it, and we have to be able to take we could be liable in ordinary negligence in violation of that statute for failure to get a player off the field to play.
One last point on this question is that $1 million of coverage that you get for being a registered MHSAA official covers you if you're sued civilly. If you're charged with a crime, all bets are off. None of that money's going to cover you. You're on your own. You're going to have to hire a lawyer, and criminal defense lawyers are quite expensive, I'm told. So you're going to have to be on your own and digging into your own pocket. So the bottom line is you don't want to be in that situation. You want to walk away. And we're going to get to a couple questions later on where we're going to get more into that. So you don't want to be in that position.
Can I add a couple quick points to close it up?
Absolutely.
We talked initially on this question about facility stuff, and sometimes those facility safety things are not easy to deal with, and sometimes it takes courage to say, this needs to be taken care of before we can play. And what I like to say in that regard to myself is, okay, it's slowing us down, but I'm here for the night, and I'm not going to hurry through this. And then my last point would be, don't forget, you can get insurance from Nassau too. You don't have to just rely on the $1 million policy that you get from MHSAA or through registration.
Very good. Thank you very much, panelists. Good discussion. Our next question is this. For primarily spring sports, many officials dress in the parking lot or other outside areas. What's the level of risk of doing this as it pertains to accusations of public lewdness? Should officials require an inside dressing facility from the school? Before I call on anybody, I'm going to touch on a couple things because this is kind of within my bailiwick as a prosecuting attorney. So what I did was I looked up the Michigan statute on this, and it isn't an issue of public lewdness per se. It's an issue of, and I know Prosecutor Spagnola will know this, it's an issue of indecent exposure. That's what the actual law is in the state of Michigan. And what it reads is, a person shall not knowingly make any open or indecent exposure of his or her person or of the person of another. If you do it, it's a crime, and there's additional penalties if you fondle yourself while you're doing it. So then the next thing I did is I went to what we call the jury instructions, because if you end up in a jury trial and there's a jury sitting there making a determination of whether you're innocent or guilty of the indecent exposure statute in the state of Michigan, they're going to be instructed by a judge as to what the law is. And this is what a jury would hear. They would hear first that the defendant is charged with the crime of indecent exposure. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant exposed his or her, and then they would have to state the part of the body that was allegedly exposed. Second, that the defendant knew that he or she was exposing that part of the body. And then there's additional instructions as to whether the individual accused was fondling that part of the body. So when I thought about this, I thought, you know, it's very, very difficult to make a determination that any sports official would knowingly do this. You'd obviously have to have some issue, mental issue, other particular problem if you did do this. But you know what? It always ends up one person's word against another. So why put yourself in that position in the first place? And I know one of the panelists, and we were having a discussion about this before tonight, wrote in that the best thing to do is come dressed if you can. Come wearing the most clothes you can. Now, you know, we're all lawyers. We come from offices. This is the kind of stuff we wear. And sometimes it's difficult to get changed in the office or in the courthouse. but you really need to make an effort to do that because you don't want to have a judge reading this instruction to a jury that's making a decision about whether you did something you shouldn't have done. So I know others want to weigh in on this.
I think I'll start. I think it would be a matter of intent. If heaven forbid you put yourself in the position that you're in the parking lot changing clothes, and you're in your car, well, if you're in the back part of the parking lot and somebody happens to come up to you, you might not, it's pertinent to say you might not have the requisite intent to have exposed yourself to another person. But then once again, that's all a matter of degree as to how that would be interpreted by a court, by a jury in that particular situation. I think going as dressed as completely as possible is clearly the best route. You know, frequently at soccer games we're changing shirts on the field or nearby the field, and clearly that's not an issue. But come as dressed as you can, and if you have to be in a situation where you're going to be changing clothes on your private areas, make sure you're in the bathroom. And ask the facility manager for a locker room if you need one. Many years ago, I had traveled to a regional game, which was a substantial distance from my area, from where I worked, and I contacted the school in advance and said I was coming from work. I wasn't going to be able to change at work. Can you provide a room for me? And they were more than happy to do so. Work with your school and your facility administration in advance so that opportunity is available to you. Very seldom do we have dressing facilities available as a soccer official, and schools will help you when they can.
I think it's important too, and I know for competitive cheer, we don't have a uniform. We don't wear stripes. We just have expectations on what we have to wear, which is basically white top, black pants or skirt, and so normally I would just, whatever I would wear to work that day is what I'm gonna wear when I'm judging a competition. But more than once, I've changed in a gas station bathroom and just, made sure there was a lock on that door, got myself ready to go so that I showed up ready to go, because you never know exactly what you're gonna be presented with. And I think you make a good point. It's important to ask ahead of time. So if you know I'm coming from work or there's just not gonna be a possibility, contact the athletic director, contact the meet manager ahead of time, so that you know what your options will be, and kind of hold yourself to the same standard that you'd hold the kids. We wouldn't expect that the kids would be out changing uniforms in the middle of the gym. So, what arrangements are we making there? The other piece that I would just throw in, kind of related to this, but totally different topic, is a lot of schools have cameras inside the school and in the parking lots now for security purposes and to be able to monitor. So just be aware if you do find yourself in that uncomfortable situation of changing in the parking lot, be really conscientious of where you are.
I have seen in some of the stores, official stores, that they sell some kind of a shield that you can set up outside your car and change within it. The only fear I would have is if there was it was a windy day and it flew over while you were in not where you want to be. So other than that, I think we're good on that question.
This does happen, okay, and I'm saying that because I defended a case, and I think Brent knows that. So it does happen. It's extremely rare, but it did happen.
Interesting. Okay, I skipped a question that I think is going to be near and dear to everybody's heart out there, so we're going to go back to it. And the question is, what are the steps that an official should take when owed unpaid game fees? It's happened to every one of us, hasn't it? And what ultimately is our recourse if they refuse to pay? Who wants to go first on that one?
Me.
Well, I will.
Go ahead, Fred.
My experience has been fortunately very positive in that respect. And oftentimes, an athletic director has a lot of things to do. Paying officials is probably 670th on the list of 100 most important things. And it isn't that they're intentionally trying to stiff you. And I have some officials I've worked with in the past jump immediately to that conclusion. Don't do that. Start with the presumption that it's an honest oversight. And what I will do, and now that we use Arbiter, I'm often paid the next day, which I absolutely love because it allows me to track payments and schedule without having 2 or 3 or 4 weeks in checks to try to match up. Start with the presumption that it's an honest oversight. And what I do sometimes, 4 or 5 days go by, I'm not paid. I send an email to the athletic director thanking them for the opportunity to officiate their contest and thanking them for being a gracious host, and then just reminding them, I haven't been paid yet. I don't know if that's an oversight, but I'm trying to match my schedule to my payments so that I can keep my own internal track. Could you please have a look at that? And when I've done that, usually within 2 or 3 hours, I'm paid. Beyond that, it's never been an issue for me. And I realize the question says, what is the recourse? Well, unfortunately, I don't know that there is a lot other than being polite and trying to work the issue out. I suppose technically you have a breach of contract claim, but you're looking at a game fee of what, $50 or $60. There isn't a whole lot you're going to be able to do about that. And my thinking is, why create an issue? Why create angst? Why be angry over it? I'll try to work it out politely, and if I can't, I'm just going to let it go.
I think a couple of follow-ups from that. If it were me, I would do the following. I'd try the athletic director or the school assistant or the AD's assistant. If that doesn't work, I'd certainly contact my own association. I'd let the president of my association know that, quote unquote, I got stiffed at this particular match. I'd like you to assist me in that regard. And many times, the presidents of those associations will get involved. We are all independent contractors. None of us have a contract with any school, and nothing can be done through the MHSAA because they have nothing to do with it either, other than if it's persistent. If it is a persistent thing, I would certainly notify the State Athletic Association. From the standpoint of what can the State Athletic Association do? They can do nothing legally, they can do things morally. Morally to talk about this, that quote unquote, listen, if you don't start paying your officials, they're not going to come working to you anymore. The one thing I would not do, would absolutely not do, would go on to my website and talk to my fellow and sister officials and say, guess what? I got stiff going to ABC High School tonight. I don't think I'm ever going to go back there again. Maybe we ought to boycott them. Worst thing to do. Worst thing to do. Let's take it to the worst extreme. Maybe you have a lot of money involved. Maybe it's a number of games, or it's maybe a situation where it's more than a few $100s that you owe. You certainly can file a claim in small claims court. You can do that against the particular schools involved. It's costly, and it probably is not worth your time or your money. And sometimes you just have to write it off. Now you have something that we can do, because all of us have to report our income as officials. You can take that off as a bad debt. So you can, it's an expense for a bad debt you can write against your income.
Good advice from Shell and Fred. The one other thing I'd add is, in my area, I would go to my assigner, who actually gave me the game with that school in the first place, and he's looked into it for me in the past, and we've gotten some relief. What I have seen is that it's some of the larger school districts that sometimes get behind a little bit, just because they have so much to do. Some of them are resource challenged. I've been in a situation where I didn't get paid for at least a year, but I knew that I was going to get paid eventually, and I wasn't going to do anything much about it. Yeah, you're right, it was $50, $60. And I knew that particular school district was resource challenged and overburdened. So, eventually they got a check out to us, and the check cashed, so that was good. Anybody else on that, Paul?
Real quick, I think your association, your officials association can intervene with the school district, particularly if there are a number of your brother or sister officials that are in the same boat as you and they haven't been paid. The association can intervene with the district or even with the conference to bear further pressure on the district so that they can adhere to their obligations.
Okay, thank you. Anybody else?
I would just echo what everybody else has said here. Be patient for your money sometimes. We seem to have just as many problems, more problems with underpayment when somebody's supposed to get 70 and they get 60. But I think the key thing is, in our association anyway, we try to route everything through the assigner so that schools are dealing with only one person. And the last thing I'd say is, in 40 years of officiating, I've only been stiffed once, and that was by one of my fellow officials, not by a school.
Whose name will not be mentioned here tonight. Okay, if the school permits activity outside of the rules, for example, spectators in unauthorized areas of a sideline, will the officials share in any liability if they do not insist on the enforcement of those rules? Who wants to tackle that one? Fred?
That's a difficult question. Schools themselves have limited ability to control some of that sort of thing. And I've thought about that quite a bit, and I'm thinking not so much do I have liability, more so what would I do? And I think, again, going back to what we said initially about following the protocols, we need to know what those are. So we need to know whether that conduct is or isn't permissible to start with. Because frankly, you know, fans are fans, and the way I look at it, part of the cost of buying the ticket includes the right to politely jaw the officials. That's part of the game. And I personally don't take any offense to that as long as it's within limits. But if we're actually looking at something that runs afoul of the protocol, spectators, photographers, whatever, are maybe a place where they shouldn't be. I think what I would do is stop the game. And I think the first thing I would do would be approach the head coach, the home coach. Look, this is a problem and we're going to have to deal with it. Can you help me? And if I can't get the assistance that I need to get things back where they need to be in conformance with our rules, then I'm going to ask to talk to game management. And if I can't get the satisfaction there, then I think honestly what I would do is we're not going to play until we have compliance.
I can only speak for one sport, so I have to ask my sister and brother panel members regarding their sports. I know in soccer, it is mandatory that the coach has to provide a list of everybody who's on the bench. Everybody who's on the bench, assistant referees, managers, everybody has to be listed. Now the question is that a reporting rule or is that a safety rule? Is it for the safety of the game or is it just simply identification in case something happens? Photographers on a sideline, parents on a sideline, is it a safety situation or is it not a safety situation? Obviously, the high school rules mandate certain lines to be done in every sport. No one can cross those particular lines in any particular sport in high school rules. So the question then becomes, will it affect the safety of the game? Will it affect the safety of the players? My personal feeling, is if it's not going to affect the safety of the players, I'm going to make a friendly comment about it, leave it alone, but I'm not going to go crazy and saying stop the game. However, there's a however. If the people on the sideline or the touch lines are in such a manner that they're interfering with either the players, or they're doing coaching, or they're interfering with my ability to officiate the game, I probably will, not probably, I will stop the game, and I'll ask them to move away. There are other violations that may happen in each sport. You have to look at it from a standpoint, are we talking about a safety rule? Are we talking about, is it an enforcement rule for notification? What is the violation that's happening here? The key is safety versus anything else.
I think that you said what I was trying to say better than I was saying it. And to me, if we take an example, there's on a football field, there's an exclusion zone that nobody except the officials should be in when the ball is live. Now, I don't know that I've ever read a rule that says, or a provision in any rule book that says that's a safety rule, but obviously it is. And that kind of thing, I think if I were to allow fans, press, whatever in the exclusion zone while the ball is live and somebody was injured, I think I might have liability for that. So it's very important, going all the way back to some of the first comments, to understand what the rules require for when balls are live and things like that, and to enforce it.
I think too that I agree with that, Fred, that you could very well be liable if you don't enforce what could be and obviously is a safety rule. But I would just suggest you err on the side of caution. If you think it's a safety issue, then clean it up. Get the coach or the school administrator to clean it up, because if your gut tells you that's a safety issue, you're probably right. And I've always gone with my gut instincts on things like that, and I think it usually should serve you well. The other thing I've seen over the years is you'll be down, outside the box beyond the 25, and for COVID years, beyond the 20. You'd see stat people, right? And they'd be down there, and they'd be getting in the way. And I'd constantly have to move them back when I was a wing official. And now my wing guys will tell me, and I'll tell them, move them back, get them out of there. They shouldn't be there. And then, a little off topic, a lot of times they'll have a comment on the officiating, which is really out of line. If you're gonna let them stay there, they need to be quiet and just keep the stats and not tell you how to do your job. So.
Do you generally feel like you get compliance when you ask people voluntarily? Like another example with football is, in some places, we get spectators that are surrounding the end zone. Do you feel like you get compliance from them when you ask them to move back, for example?
Usually, for the most part, yes. But I mean, if it's really a packed situation, I will go to the school administrator and have him move them back, because I find that they'll listen to the school administrator more than they'll listen to the official.
I have similar thoughts. I think this is one of those areas where it's important to build a little bit of a relationship with the athletic director or with the game manager, the meet manager. When you arrive, making sure you introduce yourself, maybe sending an email ahead of time just to let them know, confirm that you're going to be there, so that if something like this does come up, it doesn't get to a point where it's a safety issue, and you're able just to have that very quick conversation with the athletic director, with the meet manager, and say, hey, can you help me out here? Those folks can't be there. My second thought too is that I think something that's important to consider is that every space looks different, and I know for my sport, for competitive cheer, and probably for swimming, or some of these other sports that are in a facility that looks different everywhere, right? So I've judged competitions in auditoriums, I've judged competitions in small elementary school gyms, in huge high school gyms where they use two panels of judges and are facing opposite directions, so that you've got fans on both sides, these sorts of things. I think it's important to understand that particular facility. Just give it a quick look, see what's set up, see where we might run into having people who are sort of in the way. I think I heard the word interference. Shell, I think you said interference, right? Like in a subjective sport where we're judging, we have to be able to see everything. And we have to be able to hear everything. And that means that sometimes the kids, the athletes are, they'll get a little too close to the mat, or, they'll get a little excited on the bench. And so, you have to control that. And as an official, I definitely think that that's my responsibility to control our space. And I think sometimes you can do a little bit of prep work ahead of time to assist with that.
Mr. Larki, would it be fair also to say that if you determined it was a safety issue, it has to be remedied?
Absolutely, 100%.
Expect the unexpected, and that goes into your pregame meeting with your partners. But expect the unexpected, particularly in these particular areas. Know your facility, discuss the particular aspects of your facility that you're going to be officiating in, so that you're not surprised if the unexpected occurs.
You aren't going, that's an excellent point regarding the facility. You don't see it with a football field or maybe a softball or a baseball diamond, but basketball courts come in all sizes and shapes, and there are some of them where the ones I like, I've got a good 12 feet back to the stands. There are some of them where they're literally right on top of you, and if you have people sitting in the front row with their feet on the floor, you can't come up the sideline without stepping out of bounds like I like to do when we transition. And I've even discussed that on occasion with athletic directors. So you want to know that is the case. That's why you know your facility before you run out there and trip over somebody, not realizing that they are where they are. And I have on occasion in some gyms that are very tight like that asked athletic directors, would it be possible to keep that front row open? Because that's going to give me the entire out of bounds. And not only is it a safety thing for me, I'm not going to trip over anything or anybody, but it makes it easier because now I can see that sideline and there aren't feet or arms in the way. So when we do have a close play and is the ball in or out, I'm going to get it right. And I explain that to the athletic director, and I've never had an issue with it ever, not even a single time.
I've done the same thing, because there's been times that they'll have competitive cheer officials in the bleachers. You know, maybe the first or second row of the bleachers, and then the coach's box would be immediately in front of it. And you'll have fans and parents, as close as we are, if they put you in the first row of the bleachers. And there's been a couple times that I've just politely asked, can we block off a little bit of an area so that we don't have, we don't have parents that can read our score sheets while they're sitting there next to us. And it's never been a problem. It's just something that I think sometimes meet managers, especially if they're new coaches, they haven't been around and done this before. It's just something they don't think about. They don't necessarily think about the officials having their own space or needing their own space, and they're usually
and I've
very
had
gracious.
athletic directors say to me, wow, you know what, that is a good point. No one has ever made that apparent to me. I think in the future, we're just going to continue to do that. You just lose one row or whatever. It's not a big deal. And if you approach it politely and professionally, in my experience at least, you're going to get a polite and professional response.
Remember, the players and participants and parents are all passionate about high school sports, and they sometimes lose their perspective. I'm using a lot of P's in this particular comment, but they're passionate about it, and they tend to maybe lose their mind a time or two. So get the assistance of your facilities manager to be able to have them in a location where everyone can be safe and everyone can, especially you're safe and all the participants are safe, so that the activity can be conducted safely as well.
Bottom line, I think, is that we all agree if you don't do something about it, you're opening yourself up to liability and a potential lawsuit, and you don't want to be in that position. Okay, moving along. What is the extent that an official is permitted to defend themselves from a physical assault by a spectator? Is this different than situations with assaults by coaches or players? Can officials physically intervene to defend a crewmate? And if so, to what extent? Paul, you want to try that one?
Sure. A person may use reasonable self-defense to defend themselves, him or herself, or another. So, for instance, if your partner is being assaulted, you may use reasonable self-defense to defend your partner, same way you were able to defend yourself. That having been said, typically as a game official, the best course of conduct may not be to haul off and hit somebody between the eyes if your partner has been pushed. Diffusing the situation, going to a safe space would probably be my first suggestion, the first action that you should take, so that the situation can be diffused as quickly as possible. If you're in a basketball court situation, and I saw this when I was a high school student, I saw an official, somebody come out of the stands after an official, immediately after a game, and they immediately were on their way to the locker room, and they got to the locker room and didn't have to use self-defense while on the floor. But getting to that situation of safety will prevent further ramifications against you on down the road, saying that you acted in excessive self-defense of yourself or others. Self-defense can be a minefield, and avoid having to get physical if you possibly can. Certainly, I believe that the facilities people will come to your aid as quickly as possible, even in the most hostile situation, and that going to this place of safety would be my first recommendation in such a situation.
Here's my thought process. I think of how students in schools are taught about active shooter, okay? So we might have an active aggressor against an official. In law enforcement, they're taught to go after the aggressor, For me, as an official, I want to look like a coward. I want to cower down. I want to look like I am being threatened substantially. I'm chicken. I'm going to run away. I'm going to try to get away as possible. I'm not going to try to, if someone punches me or someone spits on me, I'm not going to retaliate, because retaliation, for those of us who officiate, those of us who can say, we didn't see the first hit, but we saw the second hit, and we throw the person out, the second hitter out, not the first one. I'm chicken. I'm telling you right now, if someone punches me, I'm not going to punch back. I'm going to curl up. I'm going to try to get out of there as quickly as possible. I'm going to try to grab my sister or brother official and say, let's get the heck out of here right now.
I think that's absolutely the right advice, excellent advice. Walk away. Diffuse the situation by walking away. There is nothing to be gained by engaging the spectator or the aggressive individual, because ultimately someone other than you is going to make the determination of whether you are guilty of a crime or whether it was indeed self-defense and justified. And like I showed you earlier, there's jury instructions on this too, that a jury will get read to by a judge and they'll have to make a determination. And then it's out of your hands. You don't want to be in that position. And it's out of your hands in the first place because a prosecutor like me has to make the decision whether or not it was justified and self-defense. So the best thing to do is to walk away and get out of there. And you're absolutely right, Shel. Grab your other officials when the game's over and get out. And it's happened to all of us. Everybody sitting at this table has been confronted over the years. It happened to me. I'll tell you a really quick story. I was coming off the field at Guy Houston Stadium in Flint, and a fellow who wasn't from Flint, from the other team to the north, confronted me and said, your officiating was poor. And instead of walking away, I looked at him and I said, well, why don't you pass the test and come on out and help us, because we need officials. And he looked at me and he said, oh, I'm already an official. And I looked back and I said, no, you're not. No official would ever speak to another official like that. And I thought, oh, I'm so quick-witted. You know what? It was a mistake. I should have just kept on walking and gotten out of there, because it could have, it didn't, but it could have gotten out of hand. So I think all of our advice is don't confront the heckler, get out of there so that you're not in a situation where somebody else has to make a determination of whether it was justified and self-defense or not.
I think you're exactly right that that's going to be somebody else's decision, and I agree with everyone's advice in terms of separate, diffuse, walk away. But I think in a legal perspective and specific to this question, it's important to keep in mind that self-defense is a defense. It's not an excuse. It doesn't just say, oh, well, I was defending myself, so there's nothing's gonna happen because I was defending myself. No, you could still be charged with a crime, and then you would have to submit self-defense as your defense. So I think it's, we're understanding the proportionate responses and what's reasonable and what's not reasonable, but keep in mind, it's a defense, not a bar or excuse of responsibility.
And let's not forget, you could be sued civilly for the assault and battery as well as charged criminally for the assault and battery, should somebody not see it the way you do. Moving right along, since the MHSAA and many schools moved to arbiter, officials have received 1099s in situations when they historically did not, because arbiter pay combines all payments rather than divide them up by each school. Has this required officials to pay more taxes than they should? Got any tax attorneys or CPAs here? We have an architect. Let the architect lawyer weigh in.
The only thing I know about tax law is if you're asking me a question about tax law, you're asking the wrong lawyer a tax law question. Subjectively, sort of intuitively, I've always understood income is income, whether it's on one 1099 or 10 1099s or no 1099 at all. The government expects you to give them their cut. They're kind of like the mafia in that regard. But I don't think it matters, honestly. I think if anything, it may make you do what you should have done all along. But beyond that, and that's kind of a sarcastic thing to say, but I don't think it matters. I honestly don't. Income is income. Now, one thing you can do, of course, is keep track of your expenses. You buy some new equipment, you buy a new set of stripes, deduct that off from your income. You're permitted to do that. That much I do know. But beyond that, I honestly think all it does is make honest officials out of all of us.
I think the question is the one where everyone knows that if you are an employer or you are using somebody and you have a contractor, you know that you have to give a form for anything above $600 in income.
Right.
And so some officials think, well, I didn't get $600 from any one school, or I didn't get $600 all year round for the entire year. That's not the answer. The answer is it's combined total income. And you have to report, if you get $10, you report $10 for the whole year, period.
Right.
It's as simple as that.
I don't think it's the answer anyone wants to hear, but income is income, and I don't think that arbiter is making you pay more taxes than you should. I think probably before arbiter, you were paying less taxes than you should. So
Excellent
maybe
response.
just take those many years of breaks and know that you're probably gonna catch up to you at some point.
Well said, Dana, well said.
What everybody else said. Count all your income, deduct all your expenses, including, don't forget your travel expense.
Oh, yeah, right.
To each location, and file your Schedule C. All you have to do is have the data in a readable form, and your tax accountant will take care of that for you.
I think arbiter's been a godsend. I think it's great. It helps with scheduling. It helps with reporting your income. I give the 1099 to my CPA and I move on, and I think it's been great. Okay, next panelists, if there's a fight between players of opposing teams in the game that we're officiating, what obligation do we have as officials to physically intervene if it's clear the altercation is one-sided? Who wants to break up the fight? Shell, should we break up the fight?
First thing I'd be doing is getting names and numbers. That's the first thing I'd be doing. I want my names and numbers of the players that are involved. Secondly, I'm going to try to do a quick 180 degrees to see where the game managers are, the game administrators are, and try to let them. I'm going to be hesitant. I truly am going to be hesitant to try to break up a fight. I certainly am going to penalize, however, because in every sport that I know, every single sport that I know, fighting, well, except one spot, boxing, One exception, I apologize everybody, there's an exception to every rule. Okay, Fighting is a safety concern in every single sport. Because of that, I'm going to be trying to get every name and number of every player involved. I'm probably going to yell at some game administrator. The very last thing I want to do is touch a player, and especially if they're down on the floor or there's blood or anything like that, I want to stay away as much as I can.
I think that's right. I think anybody want to weigh in down this end?
Just one quick point there. I realize it applies only to football, but the mechanics manual, the new mechanics manual, the front end material where it talks about game management, it does address fighting. And that's really some pretty good advice, I think. It's specific to football, but it does have broader applications. So, you have a chance, I would say, even if you're not a football official, read the front end material of that manual. I think everybody will find it valuable.
And let's face it, many of us, I've seen the stats, the median age of officials in Michigan is up there. We're all, middle-aged, if you will. And these are young, strong athletes. I don't know that physically and in the interest of good health, we ought to be getting in the middle of these situations. So I think the advice is good. Step back, get the names and numbers, because by rule, they're out. If they throw a punch, if they're in a fight, they're kicking and punching, they have to be ejected. And you have to be able to see that, write it down, so you can not only do what you have to do then, but also report it to the MHSAA, which is mandatory.
Discuss it with your partners in your pregame. If you know your opponents and that they may have a history, discuss it with your partners as to what may happen, and figure out who's going to be watching the benches, who's going to be getting numbers and names, and how you're going to reconcile everything when it's all said and done. Discuss all that in your pregame. I know so frequently that we go into our pre-games when we've all done this together 1,000 times before. Just do what you always do, but go over those situations where something happens behind your back, if something happens off the ball, so that if a fight occurs, or there's a mass confrontation, that names and numbers are being taken down. And the other stuff will tend to settle itself out.
Here's an interesting one. Does an official have any legal recourse if a spectator were to post on social media, and we all love social media, don't we, accusation of racism or cheating with the official's name and or picture? Who wants to tackle that one? I'll start if you want. In Michigan, you can obviously sue somebody for what we call libel. Libel is a statement which is false in some material respect and is communicated to a third person, either in printing, writing, signs, or pictures, and has a tendency to harm a person's reputation. Certainly that question suggests that if not true, because truth is the ultimate defense to any action of defamation, libel, or slander, but if it's not true, that's actually, you can sue for libel. But here's what you have to be able to prove: that the person who made the statement complained of to a third person in writing, and that the statement was about you, and that the statement was false in some material respect, and the statement had a tendency to harm the plaintiff's reputation, and here's the most critical part, that you suffered some damage. You have to be able to show that you were hurt by this, and when I say damage, I basically mean you were hurt money-wise. You lost money because of it. Here's the instruction on damages. If you find the jury that plaintiff is entitled to damages, then you should award plaintiff any economic damages that plaintiff has proven. By economic damages, I mean any tangible loss suffered, like lost wages. You lose your job because somebody believed it, as a result of the statement, such as lost wages, benefits, income, or profits. Here's the key, though. You can also award attorney fees incurred by the plaintiff as a result of the statement. So if the person can prove the case and prove some economic loss, even if it's a small number, you can also get attorney's fees, and those attorney fees can be very, very large, considerably larger than the actual economic damage. And Michigan's defamation law, the libel law, allows for exemplary damages, which means they can tack on money to punish the person who did it. Now, I'm not suggesting you want to be in this position, but you do have some legal recourse if you get into that situation.
Here's the difficulty. There was a sports official, I believe in Kentucky, Mr. Higgins. And Mr. Higgins, they had a radio commentator who in fact says, well, this guy has this, I think, roofing business or some business. You know, he's so lousy. Why ever deal with him? He's such a lousy official. Let's boycott him, okay? Let's do that. Well, the case says, it's interesting, some of the words they say, devoted sports fans are not known for their even-handedness in judging referees. The sign of a true fan, it might be said, is the hopelessness of attaining some equanimity. Referees' calls change the outcome of the game, and when they do, fans have every right to read about it, discuss it, the manner in which the referees called the game. Those who step into the public spotlight, limelight, and referees, we are in the public limelight, even temporarily, even for an hour or two, must face the hazard of sometimes what comes with it, the calls that comes with it. Should they find a commentator's discussion of their foray into public life unsavory, they can't easily cry foul. Bottom line, if you're accused directly of racism, that's actionable, directly of racism. But if they say, I believe he's a racist, that's not going to do it. You won't be able to sue for that. That's a belief, If he says, I know he's a racist, then it's actionable. But if he says, I don't know, I think Paul's racist. He always, every time there's a black guy up, he calls it a foul against that person. There must be something wrong. Or he goes after blondes. There must be something with blondes that he always calls a foul against blondes or something. Or, if you're accused of a crime, if you are absolutely accused of a crime, now if a spectator says on social media, I think it was criminal what he did, that's an opinion again. It's not a crime. Your belief, your opinions don't raise to the point where you can actually go after someone. And as you've indicated, you have to actually show damages. Damages to your reputation is extremely hard and difficult to prove, because did you lose work? Did your wife leave you? Are your children not talking to you anymore? Have you lost income? If you can't show any of that, then you're going to be in a problem area. If you're mentally impaired, you're going to have to seek psychiatric help, because no one's going to give you damages. If you say, oh, I've had headaches ever since I've left this game, and it's only because they've called me a criminal, they've called me a racist, and I'm so agitated by it. Well, agitation's one thing, but if you don't get medical treatment, there's really no claim. So bottom line, thick skins. You better be prepared to be called a lot of things. And I don't know about any of you on this table, I've been called many things, many things. From stupid to dumb, that I've got 5 eyes, that I don't know what the hell I'm doing. I'm sure all of you can add whatever you want in your own. But the bottom line is, first off, think about the moment. If it's spite of just the moment, think about that. If it's published and republished, and it's defaming you, then you might have a situation. But for most part, thick skin, be prepared to take what you get because you're an official.
In preparing for this, I reviewed some material, and there was a legal information guide that was put out by NASO. Although it was in 1999, it still had a lot of good information in it. There's a good section on libel and slander. In that, if you want more details, it's on the NASO website. And they also discussed in their case at the University of Iowa, and a libel suit slander suit was brought by Jim Bain, who was a basketball official for many years in the Big Ten. And the facts there were that a student bookstore had printed derogatory T-shirts involving Jim Bain, that he was unfair and a cheat and those sorts of things. And there was a lawsuit about it, and I don't believe that he was successful in the lawsuit. So the standard is pretty high, and I don't want to get into a lot of the legal details about it, but the standard is pretty high when you bring a defamation suit or libel or slander suit.
Here's one that those of us who do contests outdoors deal with every year. If a student athlete were struck by lightning, we don't deal with that, but we do deal with lightning. During a contest, might us officials be liable if they continue to play against the inclement weather policy in the MHSAA officials guidebook? What if the strike occurred before any previous lightning or thunder? So everybody's got to have the guidebook. Everybody's got to familiarize yourself with the guidebook, and you have to follow what the guidebook says. And the guidebook says that if you see lightning or you hear thunder, you stop the contest and you wait it out and for a rolling 30 minutes until the weather clears. That is what you do. You follow precisely what's in the guidebook. Now, I've been on crews where my crew says that wasn't lightning, that was a flash bulb up in the stands because they want to get the game in and they want to go home. Don't do that. Push back against that. If you see lightning or hear thunder, I remember back in the day where thunder wasn't the issue, it was only lightning, and then we changed it up, 10 some years ago, so that if you don't see lightning but you hear thunder, stop the game, start the clock. That's what you have to do.
So my question is, what happens if there is no thunder? It's lightning, and it's a clear bolt of lightning. What's the liability situation there? That's an act of God that we did not foresee. The other way, knowing that it's thunder, we have to stop for all outdoor sports. But let's talk about that. If I were a crew member and my center or my lead official said to me, we're going to continue the game, I would refuse to. I would absolutely walk away and say, I am not taking the liability situation here. This is completely, if there's anything in sports, lightning and thunder for outdoor officials, it's the number one safety rule. Number two safety, well actually it's number two. The number one safety rule is make sure the field of play is safe to play. Number two has to be lightning and thunder.
But you would agree that if you follow the protocols in the MHSAA officials guidebook, you are reducing your potential for liability should something happen.
Absolutely.
And you're not going to take the moral liability for that either, are you?
No way.
Absolutely not.
I want to talk about my geography for just a second. I referee a number of games within a quarter mile of Lake Michigan, and it's 60 miles of open water over to Wisconsin. And lightning and thunder carries that distance, and the lightning and thunder may be 20, 30, 40 miles away. It doesn't matter. If we hear thunder, stop the game immediately where it is. Don't mess around with that policy, even though you look at the radar and the squall line is out over the middle of Lake Michigan. Remember, I'm in Ludington. If the squall line's out over Lake Michigan, 20 miles offshore, stop it anyway. The policy says thunder or lightning. It's not worth the liability on you, and it's not worth the safety of the players.
The second part of the question is, though, what if the strike occurs before there's been any previous lightning or you have heard thunder? What then? Are we liable then?
I personally don't think so. I personally don't think so, because you have no warning, there's no foreseeability at that point in time. You may know that the weather's inclement, but how many times, those of us that officiate outdoors, how many times have we shown up at the match and it's a beautiful sunny day, and particularly in the spring, the weather goes sideways. And there's thunderstorms coming across the lake. How many times that, if you don't have that warning by either a thunder or a flash of lightning, I don't think you've got liability.
I think that's exactly right, and I think to put it in legal terminology, if we look at tort law, the big determining factor is it foreseeable? And once we have lightning and thunder, more lightning and thunder is foreseeable, but that first bolt of lightning likely isn't. And there's just one thing I would add regarding the weather. I realize this doesn't directly address lightning and thunder, but MHSAA does send out those heat bulletins, and I find that useful. I'll get an email 1 or 2 o'clock saying, based on the weather today, the heat and humidity index is something you need to be aware of. And that reminds me. You get that in the back of your head, and you really need to listen to those, pay attention to those. I personally think that's a great service that MHSAA provides, because I'm not sure I would remember that if I don't get that email. But I get the ping on the phone, or before I leave the office, I get the email. And that's equally important, because the heat and humidity, especially in a sport like football where the players are wearing all the equipment, that is a significant safety issue as well.
I think one of the biggest issue for me on the thunder and lightning in an outdoor sport is the pressure that we start to feel while we're down when people want to get going again. And the answer is follow the clock, follow the rule.
I think when you follow the rule, you can't go wrong with respect to thunder and lightning. Familiarize yourself with the guidebook. Have it in your case when you come to the ballpark so you can look at it if you have to. I think it's really important to have it with you when you come to your game.
Yeah. Ignoring weather, ignoring lightning, ignoring thunder is intentional disregard. And at that point, you do run into some liability issues. We talked about it earlier with the insurance, that the insurance doesn't protect you for your intentional acts. And if it's plain as day that there's a storm, that there's lightning, that there's been bolts of lightning, that everyone in the place hears thunder, whether you really want to get that game in or not, you can't intentionally disregard that and expect to be protected.
I think that's
Have
right.
have a lightning tracker on your phone.
Yes.
I don't have one right now, so I had one that worked really well, but then they discontinued it. So I would be really curious as to what other people are using as far as a lightning tracker is concerned, so I can download that on my device. We all have smartphones, and that's a good thing to have. Anybody got one that they recommend?
I don't use a lightning tracker, but I am the back judge on my varsity football crew, and I do have a backup watch that I use in addition to the belt 40-second timer, so I'm right on that. If we have a lightning delay, I set it for 30 minutes, and as soon as we get the roll, if we have to set it again, I set it again. So I have that right on my wrist.
Here's one that fortunately is in our rear view mirror as we talk today, but is it permissible for an official to ask the vaccination status of players and coaches before officiating a game? If they're not vaccinated, would this be grounds for an official to refuse to officiate? Who among this illustrious group wants to tackle that one?
I'll take this one.
Right.
Yes, you can ask. No, it's not a reason to refuse. You certainly are entitled to ask if folks are vaccinated, but under the MHSAA policy, that would be a refusal. So to me, that's a pretty simple one. Feel free to ask, but regardless of what the answer is, that contest has to
Let me
continue.
pose a question then. Let me pose a question. You go to a school that's very fundamental, okay, a fundamental school that believes from a religious standpoint that vaccinations are anti-godly, okay? And that school does not vaccinate any of their players. And you are the first time you ever go to this school and you don't know their policy, you don't know their religious policy. And you say that's a violation of the rules because you are intentionally walking away from a game. Would you walk away for your own safety? I mean, seriously, I'm asking the question because while I don't officiate in any game at any schools where from a religious standpoint, that's one of the exceptions under the law for vaccination. Religion is one of the exceptions. I don't know if I'd want to walk to a venue for the first time ever and find out that none of the players were not vaccinated. I understand my role as an official. And I guess probably what I have to do is I better make sure I keep a mask with me at all times, even though our governor and everybody else says we don't have to mask anymore. I better keep the mask sitting in my pocket and be prepared to go.
I was gonna say, have your mask on you, make sure you have it, just in case you want to wear it under circumstances where you're unsure what the status of the players are. I know we all received a note that the MHSAA would consider this a failure to fulfill if this return of assignment was not done in advance of the day of the contest. Okay, moving along. If a member of a crew does not show for a game, should an official officiate the contest alone for potential liability reasons? Who wants to grab that one?
I can tell you what we do in competitive cheer. It's a little bit different because there are usually 3 panel judges and 2 safety judges, and so in certain circumstances you could take 2 panel judges, for example, and average their scores to even out the third. I've also been at competitions where we only had 1 safety judge and the panel judge sort of help out and you work as a team. A little bit different than trying to you know, be the umpire, a single umpire at a regional baseball game or something like that. You know, there's a little maybe more pressure, I guess, in that particular situation to have to try and operate solo. But I know for competitive cheer, normally what we would do is, if it's possible, we will continue with the event, and then the guidebook calls for the outstanding pay to be split among the remaining officials so that, you know, get a little bit of help for the extra work that you did.
I think this is kind of a common sense answer that would apply to this. First of all, if you're going to bring in another official who wasn't assigned, it has to be a registered official. You can't just grab somebody out of the stands and say, hey, throw on some stripes and come and officiate. That's going to increase your liability should you do that, and you're also going to make the MHSAA very unhappy. So that's the first thing. The second thing is, and here's where the common sense kicks in, if you can get another official, or if you're just going to do the game shorthanded, you got to ask yourself, can I do this? Am I able to professionally, competently officiate this game with this lesser crew, with me, or, you know, like if it's 2-man on a football game and you're doing a middle school game, you probably could do that. If it's 2-person and it's a freshman game, maybe you can pull that off. JV, I'm not so sure about that. I think you have to have at least 3 at that point. This is just my own common sense kicking in. I think that's how you have to look at this. Because you do increase your potential for liability if you're not able to properly officiate that game, and if something happens, then you could be in for a civil liability.
Or have a heart attack on yourself.
That too.
I mean, all seriousness, I start thinking about it. When I was 43, I didn't have a problem if someone didn't show up on a JV game. I thought I could sprint it. When I was 53, I thought differently. When I was 63, there's no way I would do it. When I was 73, you better believe that I knew that I was not going to do this game by myself. There wasn't any way. And as you talk about common sense, think about yourself. Yes, there is something terrible when there are 22 people that are sitting on a football field or on a soccer field wanting to officiate, wanting a game to be played. There may be 50 to 100 people sitting in the stand, and this may be an important game, but if you're the only official running 100 yards or 120 yards in a game, I would have some real serious feelings for your own safety, for the safety of the players, and for the safety of the game.
I think a distinction needs to be drawn about the situation where you have, and I'll use soccer and basketball as the example, because the preferred mechanic, but not the mandatory mechanic in soccer now, is for a 3 official crew. And same thing with basketball, particularly at the varsity level, is a 3 official crew. But we all are familiar with using the 2-man mechanics, the 2 referee mechanics for both of those sports. It gets a little more troubling when you're down to a single official in both of those sports. And I think that probably in both of those sports, the single official at the varsity or the JV level, you've got a problem. Now, in other levels of sport and soccer, there is I don't really want to go there, but there is a situation where there is the single referee and 2 club lines. But I don't believe that is permissible at the MHSAA level at all, where you use a club line that has very limited duties to be able to call the ball in and out of play. If you don't have 2 in those sports, I'd say think the schools, but you're just not going to be able to play the game tonight unless there is a registered official available. I have come out of the stands before to do a game in that situation where, let's say, an official was held up in traffic or something along those lines, or an official was injured. I've had an official come out of the stands to replace me when I've been injured. But I would avoid single person in both of those sports particularly.
I have a question. You're doing a soccer game, okay? It's a 2-man game, and you're down to 1 man. But there's a registered official in the stands, but not in that sport. Can you call him and bring him down?
I don't believe so.
No.
I don't believe so.
Okay. Have to be registered in the sport.
If you want to come to a cheer competition and sit there and judge it, let's see how that goes. I'll help you.
I mean, and get back to common sense. The reason is clear. If I'm not registered in soccer, I wouldn't officiate soccer. I don't know the rules.
Right.
I don't know the mechanics. I wouldn't know the first thing about what to do, so I wouldn't be of any help to you, Paul. But if I was in the stands for a football game and somebody got hurt and I had my stripes in my car, I could come down and help because I do know the rules and the mechanics of that particular sport. That's why the MHSAA has such a rule in place. Okay, next question. What's the legal definition of assault? We touched on this a little bit earlier. Should someone be prosecuted if they spit on someone? Should someone be prosecuted if he or she pushes someone who is in their personal space aside to get away? And finally, is it ever permissible for an official to touch a player or a coach? Prosecutor Spagnuolo, you want to take that
I'll
one?
start on this. The first thing to understand, and I really don't want to get into the weeds here, is that assault is more than simply an intentional touching of another. Not only is it an intentional touching of another, it is an attempt to intentionally touch another. So if I were to try to slap someone across the face and made contact, that would be called a battery, assault and battery. If I were to try to slap someone across the face, but that person ducked their head and I missed, there was no battery because there was no physical contact, but there was an assault because I tried to intentionally touch that person. Should someone be prosecuted if they spit on someone? Spitting constitutes making contact or spitting at someone would constitute an assault in my opinion. The question is, should that person be prosecuted? And that is not my decision to make today, based upon the question here. That's a decision that a prosecutor would make after reviewing all the facts and the police report that's submitted to them by the agency that's involved. Should someone be prosecuted if he or she pushed someone who was in their personal space aside to get away? That is a real minefield of a question.
Indeed.
And I would submit that any kind of response would need to be, action would need to be reasonable, because you're running across the lines of assault, self-defense, assault with no battery, assault with battery, and that's just too vague a situation where for us to make any kind of an answer, straightforward, direct answer, unless somebody else wants to tackle that.
Let me ask you a question about the spitting, okay? Because of the COVID-19 situation still within our country, all right, we know that spitting in every sport, every single sport that we can think of is a violation. Person has to be ejected in every single sport. There isn't one on the books that it doesn't happen. So we know we eject them. There's two other questions. Do we file a police report? Do we actually go to a police department and say, Fred, just spit on me? Is that something that's criminal in nature, or is it a reaction? Is it a reaction? My personal feeling is I would be more worried about my health than the crime. The crime of spitting, and I don't know, I've for 31 years, I think I've only been spat on twice or something like that, but I've been spat on. Did I report it to law enforcement? No. Did I eject the player? Absolutely. Did I report it? Absolutely. Now, the only thing I would do differently today would be I'd probably get a medical test. I want to make sure that I'm medically secure. And if in fact that I did incur some type of disease, I probably then would be talking to a lawyer.
I can tell you that, not in the sports context, but in my job as prosecuting attorney, I have charged somebody with spitting on a police officer during the COVID-19 pandemic, and there's a specific statute right on point that talks about the intentional transmission of a disease, of a germ, of this particular situation. And I think that, when you take it in the sports context, it's like everything else. If it's clearly intentional, if you think it was intended to harm the person that was spat upon, then I think there is the possibility that this person committed an assault, and this person obviously has to be ejected, but maybe they have to be charged with a crime as well. I take a very dim view of assaults against sports officials in my county, and I have charged individuals with assaulting sports officials, even during recreational hockey games where they went after the hockey official, and I found out about it. I got the police report, and I charged them with assault and battery. It's a low-level crime. It's a misdemeanor, punishable by up to 93 days and a $500 fine. And usually they don't get the jail and they don't get much of the fine, but they get the point. And the point is, you don't touch an official. If you touch an official in Genesee County, you're going to hear from the prosecutor, who is very kind to officials, because I like officials. So that's my take on this. Anybody else want to talk about assault?
I want to ref in your county.
All right, finally, last one, and this is an interesting one.
Just quick, the last part of that question also addressed whether it's ever permissible to touch a player.
Yeah.
And to me, that's a bit of a sliding scale. In a football game, for example, where I have a receiver and a cornerback, and I know those two guys, that's the star receiver, that's the hotshot cornerback, they're going to be on each other 40 or 50 times in that game. And we get 2 or 3 plays in, and they're bumping chests and doing this. I will step between them. Guys, go back to your huddle and let your play talk for you tonight. Because what I'm trying to do is lower the level of agitation, sort of de-escalate a little bit. And there is a little bit of touching there. That said, I would do that only in a football game because football is already a collision sport and there's all kinds of contact going on. But for myself personally, just to follow that through, I do girls basketball and I also do softball. I will not touch a girl, period. And I used to, when I did baseball, I would tap the catcher on the back and just, hey, are you ready to go? We're gonna go, just so he knew I'm about to make the ball live. I won't do that, not with a girl. So it's kind of the last part of that question, at least in my opinion, it's situational.
Good points. Lastly, what are the thoughts regarding the state of Michigan adopting special legislation to protect sports officials from assaults? And there actually is this chart that I got from Referee Magazine that shows the states that have colors other than gray are states that have special legislation that protect officials from assaults. And essentially what that means is if somebody is convicted of assaulting an official in one of those states, the penalties for that are harsher than they would be if they assaulted a non-official. And it only counts during the contest or coming and going from the contest. It doesn't count away from the field or the gym or the competitive arena. And there's upwards of 30-some states that have adopted this kind of legislation. Michigan is not one of them. So the question is, what are your thoughts regarding Michigan adopting special legislation to protect officials from assaults? We're gonna go right down the row here and get the thoughts from everybody, starting with you, Shel.
Fred, NASO has promoted this in all 50 states and the District of Columbia. Michigan has had this legislation before, I think 4 or 5 times, and it's gotten nowhere. I personally believe that there is enough assaultive crimes in Michigan that fit the bill. We don't need special legislation.
Fred?
Part of me wants to agree with that, but given the difficulty that we have in recruiting and retaining officials, I really think that sort of legislation might have an impact in that regard. So while intuitively I say, yeah, the law doesn't need to change or we don't need more law, I think as a practical matter, it could be a piece towards solving that problem.
I personally support legislation that would further protect sports officials. I've actually worked with the legislature to try to get it passed in the past, unsuccessfully, as Shel points out. And the pushback comes from legislators who say, well, why should we take a particular class of people, i.e. sports officials, and make the penalties harsher for them? What makes them so special? Well, the answer is we're putting ourselves out there, much like Teddy Roosevelt said, put yourself in the public arena, you have the sweat and the dust to show for it. Well, we have that. We put ourselves out there. Nobody's getting rich by being a high school sports official in this state or any other state. But I think the fact is we do need some extra protection because when we put ourselves out there, we put ourselves in harm's way, and that extra protection might help us stay safe, and I agree it might help recruit some extra officials. Bruce?
I'm not taking a contrary position to you just because you're a prosecutor, okay? But I'm with Mr. Larki. I think we have a variety of criminal statutes that can be used to handle that situation without more, and the circumstance of an assault against an official at a contest, that can always be a circumstance that can be dealt with by a sentencing judge.
I tend to agree that it's probably covered in, almost all cases are probably covered by existing laws. And I agree that there could be some benefit to the harsher penalties in terms of the comfort levels of the officials, But what I don't think is gonna happen is that the angry parent who comes flying out of the stands has running through their head, oh, I might serve a harsher penalty for this than if it was just regular assault. No one's thinking that. I don't think it has any preventative component to it. I think it would just be a punitive component, that there would be, perhaps an opportunity for a harsher penalty in that circumstance. And if a situation was severe enough, there's probably some additional penalty anyway, so.
Well,
I too worked with the legislature, as David did when I was on Prosecuting Attorneys Association. I think it was when David was president of PAM, that we worked with the legislature to try to get legislation adopted on this particular issue. And while there are a number of assault offenses that are on the books that could be applicable in these kinds of situations, I feel that an official assault bill, official assault law would be beneficial. I think it would be helpful. We are out there and we are vulnerable. We are vulnerable from that person bolting out of the stands, bolting across the field behind our back to strike us when we're not looking. We can't defend ourselves. And I feel that that is an enhancement that is often ignored in the sentencing process. And I think that prosecutors need additional tools in their toolboxes to be able to address this issue. Now, is this something that am I saying that assault on a sports official should be elevated to the class of felony class crime? No, I don't think so. I think that situation is adequately addressed. But the situation where the person comes out of the stands, I do think needs to have an additional enhancement. As I said in my very first comment on the issue of assault, I recall seeing an official assault as a 14-year-old high school freshman at a basketball game many years ago, and was just appalled by what happened in that particular incident. And I think that this official didn't see it coming, and that while there was no serious or long-lasting injury as a result of it, I think that this is something that we should take a stand on.
I think it's important too, just to kind of keep in mind that if something were to be put in place, we're all thinking of educational athletics. We're all thinking of what happens at that high school football game, or that, that middle school track meet, or whatever it might be. It's not quite the same. You mentioned the case that it was a recreational hockey, situation, that would be a protection that would extend to all officials. So, the guys umpiring the Tigers games, or whatever it might be. There's some different things to consider, and maybe kind of think of it as a broader picture and what's possible in terms of, all officials and not just educational athletics.
okay, well, we have come to the end of the line here. I want to thank the distinguished panel. We had some great conversation and some awesome legal thoughts and theories. Remember, it's not particular advice to you, but hopefully it's useful. And I want to thank the panelists. I want to thank the Michigan High School Athletic Association for hosting us. And I wish you all a good day.